age and his lack of any history, he's likely to be able to do that.
Thank you, Mr. Seeger. Anything on behalf of your?
This is a very unfortunate situation, and he is a young person with no prior criminal history. He does have good family support, and clearly this was a series of
Mr. Seeger, anything on
way. Part and parcel of the agreement calls for him to receive the benefit of PIDA. As much as he's given that opportunity, I think that he was successfully completed probation, given that he has no prior criminal history. He is a young person. He got caught up with some peer pressure. He made some bad decisions. He's learned from it. He does have big family support. Probation officer here, not that that changes the facts per se, Your Honor, but he does have a good support group wherein they have given him instructions, he's followed the conditions of his bond. I don't think that you'll have any problems with him going forward. You know, he's been very receptive and understanding of the things that he's done wrong. In lengthy discussions with he and his family members about what he needs to do going forward. He's optimistic that he'll be able to get through his probation successfully. Unlike many of my clients, he is currently working. There is a large amount of restitution that's required to be paid as part of the punishment for these particular offenses, for which he is working towards paying that. He does have some money available to him to make a payment against his court costs and fines together with the restitution. And again, Your Honor, if he had a long, extensive criminal history, I would agree with Mr. Ziegler that maybe something else may be appropriate. But because he has no prior criminal history, because he's 19 years old, maybe we give him the opportunity to just have height of probation with any jail time held over his head. I really don't suspect, unlike maybe some of my other clients, and not like attacking my other clients, but he's somewhat distinguishable in as much as he has seen the foresight of what he has done as being wrong. He's also working, and he also wants to pay off his restitution for costs and fines as reasonably as quickly as possible, which is admirable. I do appreciate that he's accepting fault for the things that he's done, and I'm happy that he has good family support. So for those reasons, Your Honor, I would just ask the court to consider granting him the benefit of PIDA, and if it thought that jail time was appropriate, that it hold any jail time.
Thank you. Mr. Patnote, anything that you wanted to say today?
Yes, Your Honor. I realize what I did was wrong, and I am very remorseful for it. But I will not have any more problems here going forward. And I have been sticking to everything the best that I possibly can. I do have $300 to put towards everything today. But you will not have any problems with me, and I'd be very thankful if I got probation out of this.
Okay. All right. I did read through the report. I'm familiar with what happened here in your role, kind of in all of these circumstances. You're a young guy. This to me strikes me as the kind of thing that some more maturity and some life experience will, and hopefully this process of going through the criminal justice system will all combine to prevent you from doing this kind of thing again. To me, this is the kind of thing that is done by younger people who lack a sufficient degree of maturity. And so I do think that probation is absolutely appropriate here for you in your circumstance. I'm glad to hear that you're acknowledging this was wrong. You know, in terms of the killing of the deer, I'm a sportsman. I hunt, I fish, spend a lot of time in the outdoors. You can really harvest all the deer you want legally in the state if you jump through the hoops, and you know it's not a problem. You just need to make sure that you do it properly, and that you hunt within the appropriate hours and follow all the rules. And as a sportsman, if you haven't learned this already, hopefully you will. A lot of it is on you. There's not a CO around every corner out there. And so you have to have the maturity and the moral compass to do what's right, even if nobody's watching, and even if there's a fair chance you're not going to be caught. And I hope that this teaches you about that. And same thing with the porcupines. You know, frankly, I didn't know that you couldn't kill a porcupine. I thought they were a nuisance species as well. But even outside of that, the manner in which this occurred is more troubling to me than the fact that it occurred. You know, again, as a sportsman, you need to understand that there's an appropriate way to kill an animal if you're going to do that, and do it in a humane way. And that absolutely did not occur here. So I hope that you do take this as a learning experience. I hope that this is more a product of your age and maturity rather than some underlying issue. And we're going to give you an opportunity to show that. The court is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report, with the exception of paragraph 16, which is the attorney fees. Although this could call for up to 6 months in jail, I think given your circumstances, your age, and the fact that we're going to place you on height of probation, does not call for upfront jail time. I am going to impose some jail and hold it in abeyance. And it's important for you to understand that I can impose that jail time at any point. And, you know, there doesn't need to be extra hearings or anything. So if there's any indication that you're not following your probation, what that's saying to me is that you haven't viewed this as seriously as you should, and that some jail time might help impress it upon you a little more forcefully. So the court is going to impose 90 days in the Kalkaska County Jail with credit for 2 days served. The court's going to hold that time in abeyance. If you comply with your probation, you'll never have to serve that time. If you don't, then the court can impose any or all of that immediately. The court is going to order that you pay restitution in the amount of $2,000 to the Kalkaska County Clerk to be dispersed to Michigan Department of Natural Resources. A crime victim's assessment of $130, $325 in court costs, a fine of $500, a DNA testing fee of $60, $174 state cost, and a supervision fee while you're on probation of $30 per month. The court is also adopting, as Mr. Ziegler requested, paragraph 20, which is while you're on probation, you may not obtain any hunting licenses. You do have I'm sorry, this is HIDA, so there are no written appellate rights. Mr. Ziegler, is there anything else that we need to address for the record today?
No, Your Honor.
Mr. Seeger.
No, sir.
Ms. Wagner, do you want to meet with Mr. Patno today, or?
I do, Your Honor. I'll go back to the office with them.
So just make sure that you meet with Ms. Wagner, and good luck to going forward.
Thank you, Your Honor.
We do have Wexford County connected, I believe. Facts are from there, so. Sir, can you hear me?
Yes, sir. Yes, sir.
Can you tell me your name, please?
Clifford Lee McNamara.
Mr. McNamara, okay.
Yes, sir.
Sir. Okay, we're on the record in People versus McNamara. This is case number 244932. The record should reflect that Mr. McNamara is appearing today by video from Wexford County Jail. If I could have counsel put your appearances on in this file, please.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with it on behalf of Mr. McNamara.
Mr. Seeger, how did we want to proceed in this file today?
Your Honor, I would ask the court to give us an additional jury status conference. I have ordered the preliminary examination transcript. I've not yet received it. I did talk to the transcriptionist, and hopefully I received it within a reasonable period of time. Oh, you just got it. Your Honor.
Yeah, this was, well, it was filed on July 24th.
Okay, she still has not released it to me.
Okay.
But to that end, Your Honor, the court has a copy of it, but they've not sent it to me yet for whatever reason. In any event, Your Honor, additionally, there's some outstanding discovery. Mr. McNamara had made a request for certain discovery, which is my understanding law enforcement is attempting to obtain. And so to that end, Your Honor, I hope to have the information that's been requested together with the transcript to determine what we're going to do going forward.
Okay. You want to reset this for 30 days?
Your Honor, if we could come back in 30 days, it's probably helpful. But I'm not sure I'll have everything resolved within 30 days.
Okay.
But if the court scheduled another date, that will at least keep it on the calendar and at least allow us to continue discussing what we may or may not do.
Okay. Mr. Ziegler, is there any objection to that?
No, I would agree with everything Mr. Seeger said.
Mr. McNamara, were you able to hear what the lawyers have said?
Yes, Your Honor.
Yes, Your Honor. Do you have any objection to that?
No, sir.
No, sir. Okay. All right, so the court will reset this. Mr. McNamara, I'm sure Mr. Seeger is going to be in touch with you regarding your case, and we'll go forward once we've been able to get that discovery and once Mr. Seeger has the transcript. Is Miss Chris or Mr. Christie
He's live.
at Waxford?
Yes, sir.
Okay, all right, Mr. McNamara, so that's it for your hearing today. If you can let the corrections officers know that we need our next case, Mr. Christie, please.
Yes, sir.
Yes, sir. Thank you.
Thank you for your time.
Thank you for your time.
All right, Ms. Zatlin is here as well.
Okay, Ms. Atlin, if you want to come up to the podium there, please. We'll go on the record in People versus Michelle Zatlin, case number 244946. The record should reflect that Ms. Zatlin's present here in the courtroom.
Ryan Ziegler, I'm being People, Your Honor.
Tom Seeger, agreeing with Ms. Zatlin.
Mr. Seeger, how did we want to proceed with this file today?
I would ask for a short adjournment, maybe 45 days or something of that nature. This is her first appearance in circuit court. There have been meaningful plea discussions, and it's likely that this case will be resolved. In the interim, Your Honor, Ms. Zatlin has been attempting to enter into substance abuse treatment. However, for various reasons, she's not been able to get into that situation. But be that as it may, Your Honor, if the court would give us a brief adjournment, I think that we'll be able to resolve the file.
Okay, Mr. Ziegler.
I have no objection to that, Your Honor.
Ms. Zatlin, have you had a chance to talk to Mr. Seeger about how we're going to proceed?
Yes.
Do you have any objection to that?
No.
So I'm going to set this for a status conference plea hearing in about 60 days. And so, Mr. Seeger, if we're going to have a plea, we'll need to enter it at that time.
Yes, sir.
So Ms. Allen, just make sure that you stay in touch with Mr. Seeger. At that next hearing, I will need to have a decision about whether you want to accept any plea offers or not, okay?
Okay.
Thank you. That's all.
Thank
you. Okay, Mr. Christie, we're going to need you to unmute on your end there.
Okay.
Okay. Yes, can you just confirm that you are Blake Christie, is that correct?
Yes, I am.
Yes, I am. Okay. We're on the record in People versus Christie, case number 244933. The record should reflect Mr. Christie is appearing today by video from the Wexford County Jail. Council can put your appearances on in this file.
Brian Ziegler on behalf of people, Your Honor.
Thomas Sealer, praying with an idea of Mr. Christie.
Thank you. This is set for a status conference today. Mr. Seeger, can you tell me where this file's at?
Your Honor, it's my understanding that Mr. Christie is going to tender a plea to one count of criminal sexual conduct in the second degree. In exchange, all other counts would be dismissed.
Okay, so count two.
Yes, Your Honor.
All right, Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Christie, your attorney, Mr. Seegers, indicated that you wanted to accept the plea agreement in this case, which would be to plead guilty to one count of criminal sexual conduct, second degree. In exchange for that, the criminal sexual conduct, first degree, and the accosting charges would both be dismissed. Is that how you wanted to proceed today?
Yeah.
Yeah. Have you had an adequate opportunity to talk to Mr. Seeger about this plea agreement?
I think so.
Okay, would you like more time to talk to him here today before we go forward?
No, you can.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Christie, are you currently on any kind of probation or parole?
I am not.
And you understand that by pleading guilty to criminal sexual conduct second degree, that is a felony that carries with it a maximum possible penalty of up to 15 years in jail or prison and lifetime electronic monitoring once you're released and on parole. Do you understand that?
I do.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And can you tell me what's going to happen to those rights by you pleading guilty today?
They're.
That's right. You're waiving them and giving them up and you won't have them anymore. Is anybody forcing you to do that?
No.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here on the record about the plea agreement?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are guilty of this crime?
No, I'm pleading guilty. And over with.
Okay, well, I can't accept a guilty plea unless you are actually guilty of this crime. So are you telling me that you're innocent or that you didn't commit this crime?
No, I'm guilty.
Okay. The information I have indicates that this happened on or about February 17th of 2023. Is that correct?
As far as I know.
Do you have any reason to doubt that date?
No.
Okay. On that date, were you present here in Kalkaska County?
I was.
And on that date, did you have some contact with a person who was under the age of 13?
I did.
All right. And did you Mr. Seeger, do you have more information on the underlying facts? here?
Sure. So, Mr. Christie, on that date, did you interact with a Miss Tate?
Yes,
All right, and on that date, did you touch her for a sexual purpose?
I did.
And how did you touch her for a sexual purpose? Where
I
did you
touched
touch
her.
her? And that was for a sexual purpose?
Yes, I was.
And at the time, she was under the age of 18?
Yes.
Okay, and at that time, Mr. Christie, were you older than 17 years old?
I would have been 17.
Okay. All right, Mr. Ziegler, are you satisfied with the factual basis here?
I am.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
All right, Mr. Christie, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. The court's going to set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Prior to that, you will be contacted by the probation department for a pre-sentence report. And then you'll have an opportunity before that sentencing hearing to go through that and talk to your attorney. And we'll have that sentencing hearing here in the courtroom in Kalkaska County. And you'll be brought here in person. Mr. Ziegler, anything else that we need to address for the record today?
No, Your Honor.
Mr. Seeger?
No, sir.
All right, Mr. Christie, do you have any questions at all?
No, I do not.
Okay. All right, thank you. That's all for today. And the court is going to disconnect at this time. All right, is Richard Galt here? Mr. Galt?
Your Honor, he's lodged, and that's Mr. Gurmuthi's spot. It
Oh.
formerly was mine, Your Honor, but it is now Mr.
I think they were
Gurmuthi's.
going to be here. Soon.
Okay, got it. All right, let's just take a short recess. We'll come back on the record in about 5 minutes.
All right.
Benefits and stuff. Okay. And I should be out of here for things release.
Okay.
If that's what we're doing.
I don't know what she'll do specifically, because she's, like I was saying, like she's, and I get it, she doesn't totally get the control of it, but I guess she can also still have a trial when she wants.
She's welcome to. Sorry, Judge.
I don't suspect she's going to, I'm just saying.
Oh, you're gonna worry.
Yeah.
Chrissy, we get to see it's cheap. Well. His mother and her father. He has transfer. So well, oh, yeah. And finally, if you have to have trial, which this is. Yep. So. Let the witness testify to last time, so if they say something different.
Yeah.
you can-
I don't know. I missed that.
There's another, which is the Tom. Tom kind of. We have McNamara's.
Yeah.
We can't get into it without a password. But Tom's client wants something off the phone. Some exculpatory conversation that's reported on his phone. So I told Tom. Yeah.
My first. I think.
We already won.
Seeger just said that Ross Hollick is a defense attorney now?
Yeah,
Really? When did he do, well, obviously recently, but,
yeah, in the last 6 months to a year,
oh,
he was working for the prosecutor's office in,
mhm,
I want to say Berrien County.
yeah.
And then recently he moved over to a private firm. They've got a case today, but I don't think Ross is gonna be the one showing up.
Interesting. So he went to the dark side.
Correct. Betrayed his morals and principles.
It was a decent job he had down there, wasn't it, with the
Yeah,
prosecutor's office?
he was making good money at their prosecutor's office, just I'm sure he's making more in private practice. That's just how it goes.
Mhm.
And ask,
Yeah.
kind of assume.
I see Robbie and Wexford.
Okay.
All right.
Thank you. Please be seated. Timothy, we're connecting with Wexford Jail right now with Mr. Galt.
All right, thank you. All right, thank you.
Okay, Mr. Galt, I need you to unmute on your end there. Here we go. Sir, are you Richard Galt?
Yes, sir.
Yes, sir.
Okay. We're on the record now in People versus Galt. This is case number 244943. The record should reflect that Mr. Galt is present today by video from Wexford County Jail. His attorney, Mr. Germerthy, is also present by Zoom video. Mr. Ziegler is present here in the courtroom. We're set for a status conference in this case today. Mr. Germerthy, can you tell me where this file is at from your side standpoint?
Yes, Judge, thank you.
Yes, Judge, thank you.
Judge, I hear an echo.
I'm not hearing it on my end. You're coming through good here, so.
Okay.
Okay.
I got it on my end though.
Mr. Gold, if you would like to just mute yourself for a minute. Your Honor, we had a lengthy exam in this matter. The transcripts have been requested. I would ask that the court give us either 90 days to file any additional date of receiving the transcript.
Okay, are you anticipating some motions being filed?
I am, Judge, and it was a full day. It was a full day prelim, so it's going to be lengthy with getting transcripts and filing motions. So that's why.
Okay. And do you think 90 days would be enough time to get the transcripts and get the motions filed?
If the court would grant 120 days, I think that would put us on the safer side.
Okay. All right, Mr. Ziegler.
And Your Honor, given the nature of this case, I have a particular objection to that time frame.
Okay. All right, Mr. Galt, were you able to hear all of that?
Yeah, it's breaking up, but I.
Okay, do you have any questions at all?
Nope.
Okay, so the court's going to set this for a plea and motion cutoff at 120 days. If there is no plea entered on that date, then the court will get it docketed for trial following that period of time. So Mr. Germerthy, any motions need to be filed and set for hearing within that next 120 days, you know, with the exception of, you know, trial related motions, but any preliminary motions or dispositive motions.
Yes, Judge. And Judge, just so you have it in your notes as well, and we'll have a better idea once for the trial and plea cutoff. Anticipate this will be a 5 to 7 day trial.
Okay, all right, thank you.
I would agree with that, Your Honor.
Okay. All right, Mr. Germerthy, anything else we need to address for your side today?
No, sir, thank you.
Mr. Ziegler.
There you are.
Okay, thank you. That's all for today. And all parties in this case are free to disconnect at this time.
Thank you, Judge.
Thank you.
Mr. Galt, if you can let the jail know there, I think our next hearing is with Mr. Summers. If you can ask the corrections officer to bring him into that room.
Okay, do you want me? Okay, do you want me?
I think Mr. Shaw said that Mr. Summers was here.
Oh.
But that's what I just heard a minute ago. I could be wrong about that because it says he's by Zoom.
My jail list says Wexford.
And he is in Wexford. I did talk to him over Zoom there, so.
That's a August 8th.
I'm all set, the judge. I'm all set, the judge said. Summers.
She said like she was here. I said.
Your Honor,
Yes.
Mr. Summers is
Mr. Summers is no.
Okay. Do you have a Michael English?
Yes, sir, we'll bring him.
Yes, sir, we'll bring him.
Okay, perfect. Thank you. So, Mr. Travis, I guess Mr. Summers must be here. I don't know where Terry went, so.
Okay.
Let's see if we have Mr. Summers in our jail here.
Yes, he's right. Yes. You want him now then?
After this next case.
Okay. Did you want to talk to him?
We're doing a good job. Yeah.
I didn't see it, but I talked to Mike about it. He said the same thing.
Shocking.
It's a shit.
Well, I guess I should have Mr. Summers first. I thought they were gonna bring right in.
If you want to take them up, that's.
Yeah,
Mr. English.
Terry, can you get Mr. Summers?
Yes.
Walks in, I'll bring him.
Of course.
Yeah.
I believe this is over.
Takes these bags.
Summers, I'm gonna have you come right up to the podium there, your attorney. Go on the record in People versus Dustin Summers, case number 224654. Mr. English, I'm just gonna have you wait for just a minute, okay? We're in the middle of another case. We'll get to yours here in just a second, but stay right where you're at. So again, this is case number 224654. The record should reflect Mr. Summers is present here in the courtroom today. If I could have counsel for your appearance.
I'd say we're on behalf of the people, Your Honor. Kyle Travis on behalf of Mr. Summers.
Okay, Mr. Travis, how did we want to proceed on this file here today?
Your Honor, it's my understanding from looking back at the file that Mr. Summers did enter into a plea with possession of analogs. A bench warrant was issued when he did not appear to sentencing some time ago. Probation pool, I think, sent out a case update indicating that they couldn't conduct their PSI and basically was asking for him to be held in jail pending, if he had appeared in sentencing pending that. So I believe that status wise, we need to get a PSI done and instead of sentencing, to update the court on Mr. Summers' situation. Has obviously not been in our system for some time now, but he was actually in Kent County for a large portion of that. Did some time there, was even released from Kent County, not brought back here, was on probation, got a probation violation, served some more time, and then ran into law enforcement a little bit closer, not here, I think, was it in St. Cloud?
No, I've never had a probation violation, and I did my time there, pretty clear, and they released me. I went back to work, but now I've got my medical issues that are quite.
Where'd you get picked up at?
In Greenville.
You're in Greenville, okay. And then, I guess, picked him up from out here, so he's been here for a couple weeks now. That's his status. He is concerned, he's got some fairly serious medical issues. I think it's infections in his bone, actually. I'm not exactly sure. It appears as though they booked him out of Wexford. I don't know all of what that's about. Did you already go to the ER? Okay. Looks like he had taken a trip to the hospital just recently.
Okay. All right, Mr. Ziegler.
Yeah, I think all that's accurate. Defendant is currently being held pending sentencing. He did enter a plea. I have concerns that if he's released on bond, that he won't cooperate with the PSI process, just as he did not do previously. If there's any medical issues that need to be resolved, I'm confident the jail can either assist him in taking him to and from the hospital, or alternatively, he can seek a medical furlough if there's a good medical reason that can be authorized. But short of that, Your Honor, I would ask that he be held pending a PSI interview and sentencing at the court's next available date.
Okay. All right. Well, first of all, we do need to get through the sentencing process. It's been 2 years. It's just been out there. So this case isn't just going to go away.
No, that's right.
So we need to get that process started, get the PSI done. In terms of any medical furlough, I would need to have some kind of documentation from healthcare providers saying that, you know, your health is in danger if you're got lodged at the jail. If I receive that, then I'll make a determination about when and how you should be released pending sentencing. But until that time, I agree with Mr. Ziegler. You know, you having been basically absconded on this case for 2 years. I don't have a lot of faith that if I just release you, that we're gonna see you for sentencing. So the court's gonna order that your bond remain revoked pending some kind of confirmation of medical conditions by a healthcare provider. The court will set this for a sentencing hearing at its next available date. And Ms. Wagner, are you gonna be the one doing the PSI in this case?
I believe so. I can
Okay.
just reach out to him.
Okay, so Ms. Wagner's gonna be in touch with you to complete that pre-sentence process, okay?
Yes, sir.
All right, thank you. That's all for today.
Thank you.
Okay, Mr. English, are you able to hear me okay?
Yeah.
All right, and you're Michael James English, is that correct?
Yes.
All right, we're on the record in People versus English, case number 244923 and 4925. The record should reflect. Record should reflect Mr. English is present for this hearing today by video from Wexford County Jail. If I could have counsel put your appearances on, please.
Ryan Ziegler, on behalf of the people.
Michael Horowitz on that, Mr. English.
No, you're not. I told you. You're not. I told you. Hey, it's fine, bitch.
Okay. Record should reflect, I don't know how much that came through, but I think Mr. English indicated that he wants to fire you, Mr. Horowitz. He used the expletive, and for the record, he's now left the hearing room. So I'm going to take that as Mr. English's choice not to participate in the hearing today. As far as I'm concerned, Mr. Horowitz, you're still counsel of record. So can you tell me what the status of those 2 files is?
Your Honor, I have recently provided Mr. English with analysis and transcripts, and Mr. Ziegler extended a plea offer today that I would need to convey to Mr. English. I'll do so by mail. My last communications with him was also by mail. Well, it was by letter. I dropped it off in person at the Wexford County Jail. That said, given that he does not have the plea offer today, I would ask for another hearing. In terms of his request to fire me, I think that people don't get to choose their attorney through MIDC appointments. He's already had one shuffle of attorney who was previously represented by Mr. Travis. I think at this point, if he wishes to hire counsel or wishes to represent himself, that's a request that he could make to the court. But I don't think that he gets to pick appointed counsel.
Yeah, I couldn't agree more. So in terms of, and I'm just raising this given this kind of erratic behavior on the record here today. I don't know how much and to what extent you've had contact with him. Do you, at this point, do you think that we have a competency issue?
I don't believe there's a competency issue. I most recently met with him in person at the Wexford County Jail this week. I would say he was difficult, but I didn't have any concerns about competency.
Okay, thank you. Mr. Ziegler.
Your Honor, I would agree with everything Mr. Horowitz said. I did convey an offer today. We've had some limited plea discussions due to the fact that prior to the preliminary exam, the defendant really did not want to consider any offers. So we held the preliminary exams in this case. I've had some discussions with Mr. Horowitz since he's taken over the case. He'll have to convey those offers to Mr. English. And I agree with Mr. Horowitz and the court's sentiment regarding the attempt to fire Mr. Horowitz. I don't think the defendant gets to pick and choose attorneys until he's satisfied. So I would ask, to the extent that the court takes that as a request from the defendant, that request be denied.
Okay. Couple other questions here, because what I'd like to do is, given the nature of the proceeding here today, I'd like to get this scheduled and on the trial docket so that we have an end foreseeable to both files. Mr. Ziegler, are you going to be making any requests? I don't know how related, if any, these files are to consolidate these for trial.
Your Honor, they're related only in the sense that we were looking for him on the first file when he fled and loaded on the second file. Factually, they're fairly distinct, so I don't anticipate making any motion to join.
Okay, Mr. Horowitz, are you going to be
with that?
Okay. So it sounds like Mr. Ziegler, the case that we should try first would be the indecent exposure file.
That would be the one that was first in time, Your Honor, so I think that makes sense.
Okay. So that's file number 244925. So Mr. Ziegler, how many days of trial do you think it would take for that case?
Your Honor, other than the fact that there might be a somewhat extended voir dire process just due to the nature of the charge, I don't anticipate needing more than a day for that.
Okay, Mr. Horowitz.
I think that's accurate. I think that any witnesses that we would call will already be called by Mr. Ziegler. So I think that the people's estimate is probably accurate.
Okay, so we'll set that for a one-day jury trial. Mr. Horowitz, are you anticipating any pre-trial motions in that file?
No, Your Honor, not at this point.
Mr. Ziegler?
I don't believe so, Your Honor.
Okay. So we'll set that for trial at about 120 days out. Was that enough time for both of you to be ready?
Yes, Your Honor.
Yes, Your Honor.
Okay. And then for the court's usual procedure, we'll set this for a final status conference prior to the trial date. I am going to set this for another hearing in about 30 days. So that Mr. Horowitz, you have an opportunity to at least attempt to convey those plea offers to Mr. English.
I'm going to do so today by mail, Your Honor.
Okay.
And of course, a welcome call on his behalf. You can call me collect. I've made that known. I think I'll also offer to him to request a representation hearing at his behalf if he wants it, for him to address whatever concerns with representation or whatever he wants to do with representation. I'll make it known to him that that's something we could request if he wants it.
Okay, thank you. Okay, Mr. Ziegler, anything else? Oh, and then I'll just indicate for file number 4923, which is the fleeing and eluding trial, that the court will schedule that once 4925 is resolved. Any objection?
No, I got you.
Okay. Thank you. That's all for those two files.
Thank you, Judge.
Thank you.
And we have the 10 o'clock with Mr. Ross. And those folks are connecting right now.
Hello.
Hello. All right, we're on the record now in People versus Aaron Ross, case number 244882. The record should reflect Mr. Ross is appearing today by video by prior approval of the court. We have Mr. Ianni here on behalf of People. Mr. Travis is here in the courtroom on behalf of Mr. Ross. This is the date and time set for a sentencing hearing in this case. Mr. Travis, did you have an opportunity to go through the report with Mr. Ross?
We did get a chance to, I sent it over to him and we did get a chance to discuss it on the phone.
Okay, Mr. Ross, did you have an adequate opportunity to speak with Mr. Travis about the pre-sentence report?
Yes, sir.
Yes, sir. Okay. Mr. Travis, are there any additions, deletions, or corrections to that report?
Your Honor, I guess I would say we did get an email from Ms. Wagner updating payments that were made. I did check with a friend of the court this morning. In addition to those payments on August 5th, I believe another $350 was paid. Just as way of an update, the report is accurate when it's written. And the other issue I did mention to Ms. Wagner is it's listed at number 9 under the recommendations. It lists the requested $5,432 as restitution. I would note there is a statute on that that does authorize Your Honor to order that, but it would refer to it as a cost. So I mean, it's somewhat semantical, but sometimes restitution has an effect on, is treated differently. So I would just note, I would say under statute that that's authorized to be included as a cost, not as restitution. I would also note, it does say actual and reasonable. That does seem like a very large number, but that's what I have relative to that.
Okay. All right. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
All right, thank you. Mr. Ianni, do the people have any additions, deletions, or corrections to the pre-sentence report?
We do not, Your Honor.
We do not, Your Honor. And do you have any challenges to the scoring of the guidelines?
No, Your Honor.
No, Your Honor. Mr. Ianni, I know that there was contact by the probation officer in terms of the pre-sentence report with the victim, and I've read that as part of the PSI, but do you have any victims that wish to address the court today?
Not today, Your Honor.
Not today, Your Honor. Okay, and then Mr. Ianni, anything on behalf of the people for allocution?
No, Your Honor, we would ask.
No, Your Honor, we would ask
the
the court to
recommendation.
follow the recommendation. Thank you. Mr. Travis?
Yes, Your Honor, largely we would ask the court to follow the recommendations. It is hopefully Mr. Ross can do well. It hasn't been perfect, but he has been doing reasonable in making payments while he's been out. As the report indicates, he's had some struggles. I know He had at one point been pretty excited. He had a pretty good job, but he was not able to keep that due to some other issues. But he's working on working more for himself, and I think still pursuing employment and making payments. And that's the name of the game here. And we would ask the court to follow the recommendations.
All right, thank you. Mr. Ross, is there anything that you would like to say today?
I think that all covers it.
Okay. All right, so the recommendation here, and we discussed this at length as part of the pretrial process and arriving at a plea agreement in this case. So I'm not going to go through all the different scenarios that may play out with regard to the plea agreement. But I do think generally, and in this case and in most child support cases, that this is an appropriate resolution. The goal is always to get money to the payee parent and ultimately to the child or children. And so I think that this plea agreement is designed to do that. And so the court does not object to following that recommendation. So the court is going to place you on a delay of sentence for a period of 12 months. The court is going to adopt as the conditions of that delay all the terms and conditions that are listed in the report. And of course, the most important of which are to make the support payments as required by the plea agreement. The court is also going to order a DNA testing fee of $60, $68 state costs, a crime victim's assessment of $130, court costs of $325, and attorney fees of $350. In terms of the court costs and attorney fees, Mr. Ross, if you speak to your probation agent, I would rather see that money go to the other parent in this case. So the court does have a framework where you can do community service in lieu of paying those court costs and attorney fees, but that's ultimately up to you. In terms of the restitution amount, I did have a chance to look at that statute prior to the hearing today. And so before the court orders that as a cost, Mr. Ianni, I do think that the court would need to have some kind of documentation of an accounting of those costs. So I don't know if you have a breakdown or how you or probation arrived at that number, but if you can just provide the court maybe within the next 14 days of a breakdown of those costs. So the court's going to hold that open for purposes of today's hearing.
We'll forward a invoice to both the court and defense counsel.
Okay, very good. Thank you. And so then, Mr. Travis, if there are objections, then I would just need you to file that as to the amounts.
Thank you, Your Honor.
Okay. Otherwise, Ms. Wagner, are you going to be the supervising agent during the delay?
Yes, if Mr. Roth can.
Yes, if Mr. Roth can call me this afternoon.
Okay, so Mr. Ross, just make sure that you follow up with Ms. Wagner later today, okay?
Yes, sir.
Yes, sir.
Mr. Ianni, anything further on behalf of the people?
I would just suggest.
Your Honor, that we
sentencing and perhaps one
report
that we can come in and see how things are going.
Okay, my office typically does set that date out for the actual sentencing date at the expiration of the 12-month period. I don't have a problem setting an interim date. Mr. Travis, do you have any objection to that?
I don't. I would just ask that, again, Mr. Ross be allowed to appear by Zoom for that.
Sure.
No objection.
So the court will set, the court, I'll call it a delay of sentence review, and I'll set that in about 6 months, and we'll set it by Zoom. So all counsel and Mr. Ross can appear by Zoom if they choose.
Thank you, Judge.
Thank you, Judge.
Okay, thank you. That's all for today. Mr. Ianni and Mr. Ross, you're free to disconnect at this time.
Thank you.
Thank you.
You have either of your 10:15.
I
That's ready.
believe Mr. Stickney is gonna be from Wexford and. Let's see if I still.
Okay. I'm just gonna take a short recess, 5-minute recess. Mr. Travis, are you ready on this Stover's case?
Your Honor, I reached out and I called Ms. Stover. She was confused as to the date. She thought it was Thursday, but she is on her way up here. So she'll unfortunately be a little bit late.
Okay, how about Mr. Stickney?
Mr. Stickney, as my understanding, is in the Wexford County Jail.
About Mr. Horrocks?
He is here. Mr. Traeger is actually his attorney.
Morning, Your Honor. Morning. We'll call that case. I don't see Wexford connected yet, so. People versus Jeremy Horrocks, case number 244911. If I could have counsel put your cases on.
Brian Ziegler on behalf of the people, Your Honor.
Joshua Traeger on behalf of the defendant, Jeremy Horrocks.
All right, so Mr. Traeger, I did receive some documents here regarding the plea agreement and transfer jurisdiction to a treatment court.
That's correct, Your Honor. Just for some background, Mr. Horrocks now lives downstate in Wayne County. So the receiving court, the 23rd District Court, offers a treatment program, a sobriety court that Mr. Horrocks qualifies for. I've been in contact with the probation agent there who has assured me that they're prepared to accept Mr. Horrocks' case. Mr. Horrocks comes before this court on a third OWI in relative recent history. And I think this is a good opportunity for him to see a specialty court program that will allow him to become better over time.
Okay. Mr. Ziegler?
Your Honor, I support the court transferring jurisdiction pursuant to the memorandum of understanding. I think that Mr. Horrocks certainly needs the treatment that sobriety court can offer him. And anything we can do to get him that treatment, I think, is in the best interests of both Mr. Horrocks and the community in general.
Okay. All right. So Mr. Horrocks is going to plead guilty today as charged, and then we'll proceed with sentencing him into the sobriety court program. Is that how we're going to go forward?
That's correct. So the only consideration for the court and what I talked to Mr. Ziegler about is if you're looking at the memorandum of understanding, Your Honor, on the second page under the fourth paragraph that starts where jail sanctions and incarceration sentences will be served, there are options for the transferring court. I certainly believe that the third option to bring this case back to Kalkaska County would be appropriate if it's in the interest of the people. Because ultimately, if Mr. Horrocks fails to complete the sobriety court program, given his history, I think it might be in the interest of the people of this county to ensure that the court retains jurisdiction in those circumstances.
Mr. Ziegler?
I would agree with that, Your Honor. I think Mr. Horrocks has a very, I don't want to say lengthy history, Your Honor, because it wasn't that long, it was about 18 months, but he picked up several OWIs in a very short period of time. I think our community has an interest in sanctioning him if he fails to complete the sobriety court program. So I would agree with Mr. Traeger and ask the court to check that box.
And do you have originals of that memorandum of understanding?
I don't, Your Honor, in terms of wet ink originals, the only reason being that I've exchanged them only via email with the prosecutor's office.
Okay, so I guess I'm just going to ask counsel to provide that at some point so the court can sign an original. That'll be a copy for the receiving court.
Yes, Your Honor.
But we'll go forward with the plea here today. Mr. Horrocks, have you had an adequate opportunity to speak with your attorney about this?
Yes, Your Honor.
And is that how you want to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Horrocks, are you currently on any kind of probation or parole?
No, Your Honor. No.
Okay. And you understand that if you were to fail to successfully complete the sobriety court program, that a conviction for a third offense operating while intoxicated would be entered against you, and the maximum possible penalty you could face for that would be up to 5 years in jail or prison and or a $5,000 fine.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've discussed here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The information I have indicates this happened back on March 13th of this year. Is that the correct date?
Yes, Your Honor.
And on that date, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol, did you operate a motor vehicle on Mobile Circle here in Kalkaska County?
Yes,
And did you have any blood or breath tests done to determine the level of alcohol in your system?
That's right.
Do you know what that result was?
I mean, I don't remember.
Over 0.08?
That's right.
Do you have any reason to doubt the accuracy of that test?
No, Your Honor.
Okay. Had you previously been convicted of operating while intoxicated in March of 2023 in the district court here in Kalkaska?
Yes, Your Honor.
And then also in September of 23 here in the district court?
Yes, Your Honor.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Traeger?
Yes, Your Honor.
And Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
I agree.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court will in taking this plea?
Yes, Your Honor.
Mr. Traeger?
I agree, Your Honor. Thank you.
All right. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that Mr. Horrocks is guilty of this charge. The court will accept the plea. We'll set this matter for a sentencing hearing. Again, if counsel can just make sure that you get signature copies of the necessary documents to transfer at that time. Mr. Horrocks, you're going to meet with the probation department here today before you leave to set up a pre-sentence interview, okay? Mr. Ziegler, anything else that we need to address?
No, Your Honor.
Mr. Traeger?
Your Honor, the only other question we had before the court, Mr. Horrocks was released from confinement on bond, a substantial bond of $30,000. Given his guilty plea, Mr. Horrocks would ask the court to release him from those bond conditions at this time, especially given this matter will be transferred to a court closer to his home for probation at that point to handle his case moving forward.
I'm going to order that he remain under the bond conditions until the time of sentencing.
Yes, Your Honor.
So the court's going to deny that request.
Yes, Your Honor. Thank you.
All right, thank you. That's all for today.
Thank you.
Mrs. Silver is here in the courtroom.
Okay. People versus Stover, case number 244924. Record should reflect Ms. Stover is present here in the courtroom today. And Mr. Travis, how did we want to proceed on this case?
Your Honor, we would be asking the court for further adjournment. The court did grant us an adjournment to look into sobriety court. We had towards the end of the month not been able to speak with the probation officer relative to that, and speaking with Mr. Ziegler this morning, found out she reached out to him to let him know that she'd been on vacation for a bit. So we would still like a chance to have that process happen to see if Ms. Stover can get into sobriety court.
Mr. Ziegler?
Yeah, it's a fair statement. We were trying to reach out to Ms. Gomez throughout last week to try and determine Stover's eligibility. Unfortunately, she was on vacation that entire week, so we don't yet have an answer. I have a meeting this afternoon with the sobriety court team. Hopefully we'll be able to get an answer to Mr. Travis. Particularly, there's a question as to whether she's ever been through the program before and if that would impact her eligibility. So those are things I'm going to have to talk to Ms. Gomez about, but hopefully if the court gives us another 30 days, we'll have an answer.
Okay, so I am gonna set that as a cutoff, so we need to have some progress one way or the other by that next date. So Ms. Stover, just make sure that you stay in touch with Mr. Travis and make sure that you follow up with any requests for information from the Sobriety for program, okay?
Yes.
Anything further today, Mr. Ziegler?
No, you're right.
Mr. Travis?
Nothing further, Your Honor. Thank you.
Thank you, that's all for today. All right, I'm going to see if we can get in touch with Wexford on Mr. Stickney because they still have not connected. Okay. All right, we have Wexford connecting here. Hopefully with Mr. Stickney.
Can you hear me?
Yes, thank you. All right, sir, are you Mr. Stickney?
Yes.
Yes. Okay, we're on the record in People versus Nathan Stickney, case number 244937. The record should reflect Mr. Stickney is appearing today by video from Wexford County. If I could have counsel here put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Pat Travis on behalf of Mr. Stickney.
Okay, Mr. Travis, this looks like Mr. Stickney's first appearance before circuit court in this file. Can you tell me the status from your standpoint?
Yes, Your Honor, we have been in plea discussions and have spoken with Mr. Stickney. My understanding of the offer is that if Mr. Stickney pled to count 2, which is a home invasion first degree, all other counts and habitual offender enhancements would be dismissed, and that Mr. Stickney would like to accept that offer to a home invasion first degree.
Mr. Ziegler?
Fair statement, Your Honor.
Okay, and I'm sorry, if you could repeat again, plea to count 2, all other counts dismissed and the habitual as well?
Correct, Your Honor. Everything else will be dismissed.
Okay. All right, thank you. Mr. Stickney, did you have a chance to talk to your attorney, Mr. Travis, about this plea agreement?
Earlier, yeah.
Okay, do you need more time to talk to him about this before we go forward?
Yeah, that would be all right.
All right, do you want to talk to him today, or do you want the court to delay this hearing until a different date?
We can delay it.
All right, Mr. Travis.
If that's what you would like to do, I guess that's what we can do. I could try and Zoom in with them. I don't know if the court could put me in a breakout room or not, or if that was.
I can definitely do that if you want to talk to him today and see whether or not it's the kind of thing that we need to take more time. I mean, my concern, of course, is that Mr. Stickney is fully aware and is going to enter into a voluntary plea today, and if that means we need to take more time, I'm willing to do that, so.
No, definitely, Your Honor. I guess I'm not knowing exactly what the issue is. I can't tell you.
Okay, understood. So, Mr. Stickney, if we need to move the hearing date today, we will, but I'm going to have you I'm going to put you into a breakout room with your attorney so that you can have a private conversation with him, and we'll see whether we need to delay this or whether we can go forward today, okay?
All right.
Just so we're looking at that, step out and Zoom in.
Okay, Mr. Travis, I'm going to put you guys into that breakout room at this time. Okay, while we're waiting for that, is Mr. Knoll present?
Yeah, sure.
People versus Jeremy Knoll, case number 234798. And the record should reflect Mr. Knoll present here in the courtroom today. If I could have.
Ryan Ziegler on the FPR.
Michael Horowitz on behalf of Mr. Knoll.
And Mr. Horowitz, we're here today for a probation violation hearing. How do you want to proceed?
So Judge, I think it depends on what the people intend to proceed with. There are numerous allegations of violations. I think that several of them are not provable, and probably won't be pursued if depending on what the people intend to pursue today, Mr. Knoll was prepared to admit the allegations involving firearms.
Okay. All right.
Your Honor, Mr. Knoll wanted to enter a plea to the count related to possessing firearms in violation of his probation. We would accept that plea.
Okay. Mr. Knoll, do you need more time to talk to Mr. Horowitz about this?
No, sir.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower your hand. Mr. Knoll, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes, sir.
Okay, and you understand that by pleading guilty to this violation, you're going to be giving up that right?
Yes, sir.
Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is possession of methamphetamine, which is up to 10 years. Do you understand that? With that in mind, what is your plea to the alleged violation regarding your possession of firearms?
Guilty, please, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything?
No.
Is it your own free choice to enter this plea today?
Yes, sir.
And are you pleading guilty because you did violate your probation?
Yes, sir.
Back in January of 2024, you were on probation here in Kalkaska County, is that correct?
Yes.
And were you aware that one of the conditions of your probation was that you were to not be in possession of any firearms?
Yes, sir.
And on that date, did you in fact possess a firearm?
Yes.
The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged at count 3. The court will accept the guilty plea. How did we want to proceed in terms of sentencing? Mr. Ziegler or Mr. Barrett, do you know whether or not you're going to be recommending any additional jail time? Or do you need an opportunity to talk to Mr. Knoll and prepare?
I mean, I think there's additional jail time warranted. That being said, this has been going on for quite some time. We recently just served 6 months in the county jail for an unrelated offense. I guess I'd leave it up to the court's discretion how we move forward. I don't have any objections to a unsuccessful discharge. He has already established approximately 150 days worth of jail time, jail credit. So I guess I'll just leave it to the court's discretion to move forward.
Okay.
And it comes, I'm sorry,
No.
and just revoking HIDA with an unsuccessful discharge, so.
Okay. I think given the potential consequences, to be fair to Mr. Knoll, I think we should maybe have an updated report so that I'm fully aware of kind of the other issues. I know you did some time in Grand Traverse. I know the court imposed the sentence that it held in abeyance. So I want to have a more clear picture of exactly what time you've served on which cases, as well as the HIDA issue. So
I believe it's 7411.
or 7411. So we'll set this matter for a separate sentencing hearing. I'll just ask Agent Barrett that you prepare a violation report. So just make sure that you follow up with Agent Barrett, Mr. Knoll, and we'll go from there. Okay.
Thank you.
And Mr. Horowitz, I have Mr. Wisnatus. Connecting. I got you as counsel for that case. Is that correct?
She is Mr. Travis's case now.
Oh, that's Mr. Travis.
I'm not familiar with the name, so.
Okay. Not sure why you're in here, but that's obviously a mistake then. Okay.
Want me to get him?
He's connecting. Right, there you go. Mr. Wisnatus, I'm just going to ask you to remain connected. We're still one case behind yours and your attorney's involved in that one. So I'm just going to have you, I'm going to put you back in the waiting room and just ask you to stay connected, okay?
Just wrong.
Just wrong.
I went to look for Mr. Travis, but I think he's probably on that Zoom still.
Yeah, he is. Yep. Thank you.
Yes. Just as long as we have it before sentence.
No, we're fine. Yep, that'll work.
Mr. Jarbo, we could take your case early if you're ready.
We can do that, Judge. I'll bring her in. Thank you.
So,
She just stepped in the restroom, Judge.
Okay.
She asked if we're ready. Other things here in Kalkaska.
Busy as ever.
That's wonderful news. Wonderful. Enjoyed the drive over. No road construction.
Yeah, that's an unusual thing.
That's a plus. Hi, why don't you come with me? You can leave your purse. And we'll come out to the police, please. Okay.
And this is Miss Schuhart, is that correct?
It is, Your Honor.
yes.
We're on the record in People versus Jonna Schuhart, case number 244936. The record should reflect that Ms. Schuhart's present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of People Yard.
Good morning, Your Honor. Paul Jarbo on behalf of Ms. Schuhart.
Thank you. This is set for a scheduling status conference in this case today. Mr. Jarbo, on behalf of Ms. Schuhart, can you tell me where things stand from your side?
Yes, Judge, it looks like we have a plea agreement. As I recall from the charging document, there's 2 counts. Ms. Schuhart is going to be offering a plea of guilty to count 1, which is the welfare fraud over 500 4-year felony charge. The count 2 would be dismissed. There is an agreement as follows, that she would pay full restitution prior to sentencing, in the amount of $4,210. Secondly, that that the prosecuting attorney has offered, we've accepted and recommended the court a 1-year delay at the time of sentencing. And if she completes the delay period successfully, then the count 1 would be dismissed.
Okay. Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, Your Honor.
Ms. Schuhart, have you had an adequate opportunity to speak to Garbo about this plea agreement?
Yes, I have.
Okay, and is that how you want to proceed today?
Yes.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. You can lower your hand. Ms. Schuhart, are you currently on any kind of probation or parole?
No.
And you understand that if you were to not successfully complete that delay of sentence, that the maximum penalty that you could face for a conviction for this charge would be up to 4 years and or a $5,000 fine?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through them with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
And are you pleading guilty because you are guilty?
Yes.
And just because I think Christie was out of the room, is this a plea to count 1 or to count 2?
Count 1, Your Honor.
Count 1. Okay. Count 2 if you dismiss. Okay, so Ms. Schuhart, can you tell me what it is that you believe would make you guilty of count 1 here?
Well, I failed to report a long-term disability supplement income. And then also I had liquidated my 401k and failed to report that as well.
Okay, and so did that allow you to receive some benefits that you wouldn't have otherwise been entitled to?
Yeah, I think so, yes.
Did that occur here in Kalkaska County?
Yes.
And was that around February of 2022, that time frame?
Yes.
Okay. All right, Mr. Ziegler, are the people satisfied with the factual basis?
Ms. Schuhart, did that allow you to obtain assistance you are not entitled to, having a value over $500?
Yes.
I'm satisfied, Your Honor.
Mr. Jarbo, are you satisfied?
Yes, thank you, Your Honor.
Okay. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Jarbo?
No.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Jarbo?
Yes.
Ms. Schuhart, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a delay of sentence hearing. You'll be notified of the date and time of that. It's also important that you stay in touch with Mr. Jarbo so that you're prepared to go forward on that day. Okay.
Yes.
Before you leave today, you're going to meet with Agent Barrett to set up a time to do an interview with him.
Okay.
And that's all for today.
And Judge, we have one bond issue if we could.
Okay.
And that was, I believe, and Mr. Ziegler may discuss this with my law partner, Warren File, that Jonah's currently on weekly urine screens. And we're not aware, and I think Mr. Ziegler confirmed that this is not a controlled substance case or alcohol or substance abuse case. she's had no problems on those, but we're thinking it might be a good time to ask the court to stop the requirement of those weekly hearings.
Any objection? Okay, so Mr. Jarbo, if you can do that by stipulation in order, it sounds like the prosecutor is not going to object, and then just submit that to the court. I'll sign that.
Very good.
Okay.
Thank you.
Thank you.
Thank you, Judge.
Mr. Travis. Okay. We'll go back on the record and People versus Stickney. Mr. Travis, did you have a chance to talk to Mr. Stickney there privately?
We did, Your Honor.
Okay. And do we need to adjourn out today's hearing?
If we could, Your Honor, adjourn it for 30 days, so we can have some further discussions.
Okay, so Mr. Stickney, I want to make sure that you're fully aware of all the consequences of entering into this plea. So the court's going to set this for another hearing date to give you time to continue to discuss it with your attorney, okay?
All right.
All right.
Okay, thank you. The court's going to go ahead and disconnect from Wexford at this time. And then I have Mr. Hernandez connected. We bring him in. All right, we're on the record in People versus Brennan Joseph Wisnatus. This is case number 244914. The record should reflect Mr. Wisnatus is present today by video by prior approval of the court. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the Honor. I have Travis on behalf of Mr. Wisnitis.
Mr. Travis, where are we at with this file today?
Your Honor, we had previously adjourned because Mr. Wisnitis had been interviewed by Sobriety Court in Genesee County, I believe. Unfortunately, he was not accepted into their program. So today, Mr. Wisnitis will be accepting a plea offer from the prosecutor. My understanding of that offer is to operate an intoxicated third offense with no enhancements. And we'll be dismissing the plea in a week. That's correct.
Okay. All right, Mr. Wisnatus, have you had an opportunity to speak to Mr. Travis about this plea today?
Yes, Your Honor. Yes, Your Honor.
Okay, is that how you want to proceed today?
Yes, it's a little bit. Yes, it's a little bit.
Can you repeat that for me?
He's going to turn the volume up. He's going to turn the volume up.
Okay. Are you saying you can't hear me?
I can hear you, Your Honor.
I can hear you, Your Honor.
I'm having trouble.
I don't know. If you could lean into the microphone, I think if you move back, you're becoming muddled.
Okay. Can you hear me now?
Can you hear me now?
Yeah, that's better if you kind of stay in one spot. When you move back and forth, it creates an issue with us being able to hear you.
Okay, Your Honor. That's right, Your Honor. That's right.
Okay. So, Mr. Wisnatus, if at any point you can't hear what I'm saying or you need me to repeat anything, please let me know and I'll be happy to do that. I want to make sure that you're able to hear everything that I'm saying, okay?
Yes, Your Honor. Yes, Your Honor.
Can you raise your right hand, please?
Yes, Your Honor.
Do you solemnly swear, or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Yes, Your Honor.
Thank you. You can lower your hand. So, Mr. Wisnatus, you understand that you're going to be pleading guilty to one count of operating while intoxicated as the third offense. In exchange for that plea, the prosecutor is going to dismiss the fleeing and eluding charge as well as the habitual offender enhancement. Do you understand that?
Yes, Your Honor.
Yes, Your Honor.
And you understand that the maximum possible penalty that you could face for third offense operating while intoxicated is up to 5 years and/or a $5,000 fine.
Yes, Your Honor.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor. Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor. Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor. Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor. No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor. No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor. Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor. Yes, Your Honor.
All right. The information I have indicates that this happened back in September of 2022. Is that the correct time frame?
Yes, Your Honor. Yes, Your Honor.
All right. On that date, had you been consuming alcohol?
Yes, Your Honor. Yes, Your Honor.
And after you consumed alcohol on that day, did you operate a vehicle on Valley Road here in Kalkaska?
Yes, Your Honor. Yes, Your Honor.
Did you have any blood or breath tests to determine the level of alcohol in your system at that time?
I believe blood. I believe blood.
And do you know what the result was?
0.133. I believe. I believe.
Okay. Do you have any reason to doubt the accuracy of that test?
No, Your Honor. No, Your Honor.
Had you consumed enough alcohol on that date that you believed that you were intoxicated?
Yes, Your Honor. Yes, Your Honor.
Had you previously been convicted of operating while intoxicated in 2015 in the 67th District Court?
Yes, Your Honor. Yes, Your Honor.
And of operating while impaired back in 2012, also in the 67th District Court?
Yes, Your Honor. Yes, Your Honor.
Thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Okay, Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Thank you. Mr. Wisnatus, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Somebody from the probation department here in Kalkaska will be in touch with you. Mr. Wisnatus, it's important that you follow up with that phone call when you get that and that you stay in touch with Mr. Travis. The court will set this for an in-person hearing, so Mr. Travis makes sure that Mr. Wisnatus makes arrangements to be here present. Mr. Wisnatus will have that hearing in person here in Kalkaska, okay?
Yes, Your Honor. I got one. Your Honor. I got one.
Okay.
My address is since changed. Since changed. 2345
Okay, because of the communication problems, Mr. Travis, can you get in touch with Mr. Wisnatus and then just update the clerk with his current address? Mr. Wisnatus, Mr. Travis is gonna help facilitate getting your address updated, okay?
Okay, thank you. Okay, thank you.
Okay. That's all for today, and you're free to disconnect at this time.
All right, thank you. All right, thank you.
Thank you.
People People versus Flores Campos, case number 244921. Record should reflect Mr. Flores Campos is present during the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people.
Good morning, Your Honor. Kurt Richardson appearing on behalf of Juan Francisco Flores.
Thank you, Mr. Richardson. This is your motion to modify a sentence. I did have an opportunity to review your motion prior to the hearing today. Was there anything that you wanted to present to the court by way of oral argument for that motion?
Thank you, Your Honor. We refer to the motion. The only thing additional I have is Mr. Flores Campos reports to me that he has a bleeding ulcer in his stomach. That the jail nurse has informed him he's been throwing up blood. He's unable to eat. But that's the only update as far as that. We're essentially asking for the court's mercy here today. Mr. Flores Campos has 3 young children. He has that he has to support. We're asking for any possible weekend jail sentence, GPS tether, anything possible, so he can work while serving his sentence, Your Honor. We're also asking under the law for a commutation for a 1/4 reduction in his sentence for good conduct. I think the statute supports that. We think that he hasn't had any issues. In fact, he's been suffering in jail. So we would just ask the court if there's any possible way that he can to modify the sentence. Thank you.
Thank you, Mr. Ziegler.
Your Honor, the motion was for work release or alternatively for imposition of good time. People generally don't take a position on those issues. If the defendant is otherwise eligible for work release, people believe that's a matter between the court and the jail. And same with good time. If he's eligible for good time, people generally do that as a matter of discretion of the facility. So the people don't take a position relative to whether the defendant is eligible for those things in the first instance, and also don't take a position as to whether the court should grant either of those items of relief requested.
Right, thank you. So again, I did have a chance to review the motion. I also had an opportunity to review the file prior to the hearing date today. We just had sentencing not too long ago, so I did remember this case. Unfortunately, it sticks out in my mind given the defendant's conduct during the offense. And I guess with regard to the statutory good time, the court supports the use of that by the jail, and I think periodically the court signs an order authorizing the jail to grant good time pursuant to statute. So I think that's something that's already in place and that Mr. Flores Campos will be entitled to. And I certainly don't have any objection to good time pursuant to the statute. In terms of the other issues, I mean, I articulated very clearly why I thought the sentence was appropriate at sentencing. Mr. Flores Campos' behavior during this entire incident escalated it at every stage where he had an opportunity to kind of mitigate what was going on, and he made the choice to make things worse at almost every turn during this. And I think he fully deserves the 6 months every day of it outside of the good time that he would be entitled to based on his behavior at the jail. And in fact, I don't know, I think that was a very fair sentence given his conduct and his past record. So the court isn't going to grant any other exceptions. And I think the sentence is reasonable and proportionate based on my articulation at sentencing. So the court will rely on that. In terms of any medical issues, usually if there's a serious medical issue, I do get contacted by the jail. I haven't received any information regarding that. To the extent that there is a legitimate health concern that's documented by a medical professional, and there's an opinion that Mr. Flores Campos' health would be in danger by current incarceration, I'm always willing to consider medical furloughs, but they have to be properly documented. Certainly, I would need more than what I have on the record here today.
Your Honor, if I may, the client's wife indicates that the jail indicated they couldn't release the medical record without an order from you. And so I'm not sure if that's a possibility.
If the jail knows how to get a hold of me,
Okay.
they don't have to go through relatives and third parties, and they usually don't, so,
I would assume so.
yeah, so.
Thank you.
I'm not doubting those statements, other than I have not been contacted by the jail, so.
Thank you.
All right, okay, thank you, that's all for this hearing today. That also concludes the court's morning docket. The court will be in